Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kalen Cheatham. Got a note that he was going to be late. Michelle Daly. Here. Nicholas Duncan. Here. Austin Hensley. Here. Max Juarez. Mr. Juarez would be appearing via Zoom for sanctions. Guy McSpadden. Dylan Meza. Dylan Ray Meza. I have a note that he's having car issues for sanctions, so we'll recall him. James O'Brien. Jace Quaid. Isaiah Rosser. Got a note that Mr. Rosser said he was running late. We'll recall his case. Caleb Waller. Ray Williams. Here. Jesse Lowry. Here. Thank you, Mr. Calabria. Juan Wilkins. David Combs. David Wayne Combs. Okay. Elizabeth Black. Trevion Bowie, CR 24-198, showing that he was arrested in Smith County on the 18th. I believe he is still there. We'll recall his case. Joshua Elwood. Here. All right, Miss Shanta Foster. We'll recall her at 9:30. She'll appear via Zoom from Gregg County, hopefully. Okay. Thanks, sir. Gerald Holmes. Charles Huff. Evan Page. Robert Wells. John Ross. Joshua Hogue. Let's see. Rhonda Alexander. Catwalla Anderson. Wesley Ball. Here. Richard Homer. Here. CR 24-165, State versus Joshua, Stephen Huffman. Mr. White filed a waiver of arraignment that was granted. Trial is set December 5th. Nicole Jones. Obed Mingastu.
Mr. Mingastu is
custody Dallas County?
Yes, sir. Check sure last time.
Okay, we'll verify and recall his case. And we'll call Mr. Creel at 11:30. Is there anyone in the courtroom whose name's not been called? Good.
Well, Elwood, I believe someone else answered for Elwood.
Elwood? Who's the attorney? Mr. Schmidt. Joshua Elwood? Is Joshua Theron Elwood here? Who answered for Mr. Elwood?
Mr. Hogue.
Mr. Hogue is not Mr. Elwood. All right, do we have any counsel that's ready? Mr. Schmidt?
Yes, Your Honor. David Wayne Combs, Your Honor.
Mr. Combs, if you would come forward, please, sir. This is cause number CR 24-94, State versus David Wayne Combs. Docket call. Go ahead, Mr. Schmidt.
It is, Your Honor. Ms. Curry and I had a meeting last week that had to be canceled, but we are very close to a plea agreement. If we could just have a couple weeks to 30 days, we should have a final resolution to this case. I apologize. We thought we'd have it done today.
Any objection from the state?
No objection, Your Honor. Thank you.
About November 12th or 14th. Oh, that's a couple weeks.
Judge, the 14th would work for me.
Would, okay.
Yes, sir.
All right, court sets Mr. Combs for a docket call. November 14th at 9 a.m.
Thank you, Your Honor.
All right, and Mr. Combs, I show that you're delinquent on your pretrial fees by $20. Have you paid those?
No, sir. I can pay him.
All right, I want you to pay those today. When you leave here, I want you to go across to the probation department and pay that $20.
All right.
Okay.
Appreciate it.
I'll have him sign. Step back, Your Honor. May I be excused?
Yeah, thank you, Mr. Schmidt. Good to see you. Yes, sir. Your name, sir?
Those on behalf of Juan Wilkins.
Mr. Wilkins? This is cause number CR 24-123, State versus Juan Miguel Wilkins for docket call. Yes, sir, go ahead.
Yes, Governor, we received an offer from the state of 8 TDC. That offer was received Friday. We have since spoken this morning about some things that, some mitigating factors that we want to present. And so we're asking for a reset, Your Honor.
Any objection?
No, Your Honor. Thank you.
All right, court's going to set a final docket call. That means that if the case is not resolved by the next setting, then I expect the defendant to tell me trial by court, trial by jury, or plea. Okay. All right, court will set. Mr. Wilkins, if you have your calendar there. How about November 12th or 14th
Your Honor, I will be, I have a vacation letter, I believe. I'll be in Georgia.
for that whole week?
Time period, yes.
All right, what about December 3rd?
Your Honor, I will be in front of you.
Here, December 3rd, okay. All right, court sets Mr. Wilkins for final docket call December 3rd. That'll be at 9 a.m. And Mr. Wilkins, I show that you're also delinquent $20 on your pretrial fees. Can you pay those today? Did you pay them this morning already? Thanks, sir.
About a week ago. I can print this.
All right, Mr. Wilkins, the court will get the white copy. Mr. Wilkins will get the yellow copy, and then he's free to go.
All right, thank you,
All right.
Judge.
Have a good day.
Last side.
We have any other? Mr. Clavey, are you ready?
Yes, Your Honor. Jesse Lowry, Your Honor.
Mr. Lowry, you'll come forward, sir. This is cause number CR 24-171, State versus Jesse Lee Lowry, pretrial.
Yes, sir.
Morning, Your Honor. Judge, I had a conversation this morning with Ms. Curry. I believe there's some issues regarding restitution that she and I'd like to have a little bit more time on to figure those out, and ask the court to reset us for final docket in about 30 days, if that's appropriate.
So no issues on pretrial other than?
No, sir, not at this time.
Okay, all right, court will set Mr. Lowry for a docket call. How much time do you need, Mr. Clavey?
That December 3rd date that I heard the court use a minute ago is.
Okay, court will set Mr. Lowry then for docket call December 3rd at 9 a.m. Mr. Lowry, also show that you're $20 delinquent on your pretrial fees. Have you paid those today?
No, sir.
All right, I'm going to order you that after court, I want you to go over to the probation department, pay your $20. See. We have any other counsel that's ready? Mr. White, you're in. Joshua Hogue, CR 24-140. Mr. Hogue is set for docket call. Go ahead, Mr. White.
Your Honor, we're going to be asking for some more time. Mr. Hogue recently got arrested on another charge. I've been appointed. And this has been like within 10 days or so. So I believe that would probably alter any type of offers that the state is making at this point.
State.
No objection, Your Honor. I need time to get that case in, review it, see if we're going to proceed on that, which will inform how we proceed on this case as well, Your Honor.
You said the rest has been within the last 10 days?
Pretty close to that, 2 weeks, something like that. He's
What was he arrested for?
failure to register. But as I said, the court has already appointed me on that case as well.
Court's going to set Mr. Hoag for additional docket call on. You want to do Thursday, December 5th?
That sounds good, Judge.
I don't anticipate state will probably have all of its cases in by then, but we'll probably treat it as a status on docket call.
And I believe that is all I have.
Here we go. Do you have anything this afternoon, Mr. White?
I don't believe so.
Okay. Trying to bring them in now, Mr. Sherman.
Can we approach while we're doing that? Yeah.
You said, do you need to? You can. Want to approach? I don't know what.
Yeah, come on.
You'll just need to make sure that you back up so she can see you.
Yeah.
Well, she needs to see you.
We're off the right.
We're all through.
Yeah.
Good morning, Ms. Foster. Can you see and hear me okay?
Yes, sir.
All right, Ms. Foster, my name is Judge Chris Martin. I'm over in Van Zandt County, which is in Canton, Texas. And today we're in court on a charge of unlawful possession of a firearm by a felon. Your attorney, Mr. Schmidt, who is here, I have appointed him to represent you. And we're going to call your case for arraignment today, okay? So this is cause number CR 24164. And Ms. Foster, I'm just going to let Mr. Schmidt make an announcement to the court, okay?
Thank you, Your Honor. May I proceed?
Yes, bring that microphone up here, or she probably won't be able to hear you.
Can
Go
you
ahead.
hear me, Ms. Foster?
Yes, sir.
Okay. Judge, Ms. Foster is in Gregg County custody. I received an order from her attorney that the court has found her incompetent to stand trial with restoration. At this point in time, we're not prepared to proceed with arraignment pending the resolution of her competency status. We'd ask that it be reset for a status hearing.
Any objection?
No objection, Your Honor. Thank you.
All right, then the court is going to reset Ms. Foster's arraignment We're gonna set it for status on Tuesday, December third. Are you available that day, Mr. Schmidt? Yes, sir. Okay, December third, we're gonna set that for status on competency. We'll also set it for arraignment. We'll carry the arraignment at the same time.
And I am in contact with her attorney in Gregg County, so she's aware of that fact.
All right, Ms. Foster, did you understand what the court did today?
Set my, incompetent hearing.
Yes, we've set another hearing to talk about your competency, and Mr. Schmidt has indicated that he is in communication with your attorney in Gregg County, and they're gonna continue to work on the case. We're gonna come back on December third and talk about it more, okay?
Okay, yes, sir.
All right, Ms. Foster, you're free to go. Thank you. Have a good day. And tell the Gregg County staff over there, I appreciate them having you on Zoom today.
Yes, sir. Thank you.
You're welcome. Have a good day. You ready, sir?
Morning, Your Honor.
Good morning.
John Ross.
Ross, Isaiah Ross?
John Ross.
Oh, Don Ross. Sorry. Who's your client?
John Ross.
John Ross. Oh, God, sorry. I thought you said Don Ross.
It's set for arraignment.
John Robert Ross, CR 24-224. Go ahead.
I'm not sure if my office filed a waiver of arraignment, but we waived arraignment and
Is his name spelled correctly in the indictment?
yes, Your Honor.
Does he understand what he's been charged with?
Yes, Your Honor.
And does he want to enter a plea of not guilty?
Yes, Your Honor.
All right, court finds that Mr. Ross has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record. Court finds that he is represented by counsel. Name is spelled correctly and he understands what he is charged with. Court will set Mr. Ross now for a pretrial hearing. Are you available December third or December fifth?
Double check, Your Honor.
Mr. Ross, while your attorney is looking for the date, after you sign your notice of setting, I need you to sign your conditions of pretrial release. Those are conditions that are placed on your bond, that if you violate, the court could revoke those. The court could revoke your bail, put you back in jail pending trial, okay? So once you sign, they will hear me with the probation officers, and they give you the pretrial release. Your attorney can come with you as well. December third or fifth?
December 3rd, Your Honor.
Third?
Yes, Your Honor.
All right. Court sets Mr. Ross then for pretrial hearing on December third at 9 a.m.
Thanks, Your Honor.
You're welcome. Come up here. And next time y'all just walk here in the front. Okay, come on up right here. All right, court's going to call the sanction court hearings. Michelle Daly. Michelle Daly. All right, good morning, Ms. Daly. How are you?
Fine, how are you?
Doing great. All right, Ms. Daly, let's see. Last time you were in court, I ordered you to pay $100 to probation and $100 to court, and it looks like you got that done.
Thank you.
Good, that's good work. All right, court finds that you are in compliance, and I'm going to order you to do the same thing, right? And so I'm gonna have you come back on December 3rd, and 100 to court and 100 to probation, okay?
For November?
Well, you're gonna pay for November, and you'll come in on December 3rd, and you'll tell me
Okay.
that you complied. But make sure that you have that turned in the week before court.
Yes, sir.
Okay. Nicholas Duncan. Morning, Mr. Duncan.
Good, how are you?
Doing good. All right, Mr. Duncan, kind of the same thing that I told Miss Burr, or I'm sorry, that I told Miss Daly, is that you were sanctioned to pay 100 to court, 100 to probation. My records say that you did comply with that, so that's good work. I'm gonna reset you also for December 3rd. Same orders, 100 to probation, 100 to court.
Okay, said 100.
100 to probation and 100 to
I
the
did
court.
200,
Did you do 200 each?
200 each.
Okay, that's good. So anything that you do over
Okay.
is just extra and goes to your credit,
Okay.
but the minimum is 100. So if
Okay, I
you
didn't
can-
know. I
if you
didn't
can pay 200,
Yes.
that's good. That means you're gonna pay down what you're owing, your arrearages. So the faster you do that, the better for you. So,
Okay.
but the minimum's 100. If
Okay.
you can pay 200, great. If you can only pay 100, that's great too.
Okay.
All right. All right, good morning, Mr. Juarez. Can you see and hear me okay?
Yes, sir.
Yes, sir. Can you see and hear me okay?
Yes, sir, I can.
Okay, Mr. Juarez, we're here for your sanctions court here, appearing via Zoom due to your work and with the court's approval. I find that you have complied with your previous orders. You paid 90 to probation. You paid $75 towards your court collection. You have complied with your 12-step program. And so I'm going to reset you for December 3rd. And I'm going to order the same thing, $90 to probation, $75 to the district clerk. These are amounts that you must pay continually every month in order to expire on time. And we also need to get you going on your community service. What can you do on community service? I know we've talked about this before, but I need you to remind me what you think you're capable of doing to get this done.
If I was probably most likely, if there wasn't a way where I could I was gonna ask you if, since I'm working full time, could you use that as my community service hours? 'Cause that's what my probation officer in Henderson County does. Since I'm working full time, she lets me do my my proof that I'm working full time, and they will go take off some hours for that.
Well, unfortunately, law doesn't allow us to exchange money for community service hours, but I'll tell you what, I'm gonna have a plan for the next time that you appear, and I'll have your probation officer tell you what it is, okay? I'll have a plan for you to discharge your hours, and it'll be something
Alright.
that you can do. I'm saying it'll be something that
All right, sounds good.
you can do that will not interfere with your work, all right?
Yes, sir. It's because I honestly do work 7 days a week. Like on Sunday, I try getting off early, but the earliest we get off is 5. But 5 is better than getting off at 7 on Sundays.
Sure. No, I understand. I understand. I'm not gonna interfere with your work. I want you to continue working. So I will have a plan in place for you and your probation officer. They will give that information to you and we'll get you going, okay? So when you come back on December 3rd, I want $90 to probation, $75 to the district court. And then I want you to continue to work and comply with your 12-step program, okay?
All right, sounds good.
All right, have a good day. We'll see you back on December 3rd.
All right, thank you, Your Honor.
You're welcome, sir. Have a good day.
You too as well.
James O'Brien. Morning, Mr. O'Brien. How are you doing?
Good.
Are you really?
Yeah.
Good. All right, court finds that you have complied with your previous orders. I'm gonna have you come back on December 3rd. Same thing that you've been doing. You're doing well. 200 to probation, 200 to court collections, 20 hours community service. And I know you probably get tired of me asking, and you probably tell me the same thing over and over, but just remind me, what are you doing for work and where are you doing your community service hours? Self-employed, like what do you do though?
I'm a mechanic,
Mechanic, what do you work on?
cars, 18-wheelers.
Do you go out and work for like a mobile mechanic or do you work for places or they bring you?
Shop.
You have a shopping van? Okay, good. And where are you doing your community service?
I usually do it in,
Heritage Park? Okay. They don't have anything over there in Van for you to do?
I have to check. I just always do it here. I live in Canton.
Oh, you live in Canton, so it's probably just as easy to go that way?
Yeah.
Okay, very well. All right, well, you're doing well, Mr. O'Brien. I want you to keep that up, okay? Dwight, are you ready?
Yes, sir, I am.
Who would you like to call first?
Let's call Ms. Jones.
Nicole Jan Jones. CR 24168. All right, Ms. Jones is set for pretrial.
Yes, sir. We don't have any contested motions today. We'll abide by the court's standing order. And we'll ask the court to move this over to docket call.
All right, court finds there are no contested pretrial motions. Court sets this matter for docket call hearing. Do you want December 3rd or 5th?
December 5th will be okay, Your Honor.
5th? All right, court sets Ms. Jones for docket call December 5th at 9 a.m. Ms. Jones, once you get your notice, you're free to go.
Who we call, LaRonda Alexander, Your Honor.
Ms. Alexander? This is cause number CR 24-162, State versus LaRonda Shante Alexander for pretrial.
Your Honor, we're having a little bit of an issue with an in-car video. I've made the DA's office aware of it. They actually copied it, brought me a disc because we couldn't, I don't think we could get it uploaded. It was a Canton PD. I think we're missing some sort of file extension on it. I'm gonna need a short reset on that.
Any objection on the statement?
No objection, Your Honor. Thank you.
Right. You need more than a couple weeks? You want December or you want the November 12th or 14th?
Let's do December, Your Honor.
All right, 3rd or 5th?
Let's do December 3rd.
All right, court sets Ms. Alexander for additional pretrial hearing December 3rd at 9 a.m. She's free to go.
Let's call, Katwala Anderson.
Catwalla Anderson, CR 23197. All right, Ms. Anderson is set on her motion to adjudicate.
Yes, sir. The essential, that there were two allegations in the motion to adjudicate. One was, community service related. The other one is an new underlying charge. Mr. Hartwell told me that they're still busy trying to get through that case. And they're gonna get me all the information when they get it all ready to go. So, I don't know how long I guess that's a Mr. Hartwell, question, but wherever the court wants to set it, I'll be ready to go if we can get all that together.
Carwell.
Your Honor, if we could get to, I guess the November, contested docket, we should have an answer by then and probably be able to work this out with Mr. White.
All right, court sets Ms. Anderson for Tuesday, November 26th at 9 a.m. Once she gets her notice, she's free to go.
Mr. Ball, Your Honor.
Wesley J. Ball, CR 23232. Mr. Ball set for pretrial.
Yes, sir. So the last time we were here, I informed the court, we were trying to, we have retained an expert on this case. And I had filed a subpoena with the DPS crime lab over in Garland. They, I believe the day we were in court, or maybe the day before, I think it was the day before, had provided us with some of the information. As it turned out, I had forwarded it to my expert. My expert went through the file, informed me that there were some documents or some files that he believed were missing. We then contacted DPS Garland, kind of went back and forth with them a little bit. They realized that they did not provide us with the information, all the information. They got on it fairly quickly, Your Honor, and got it to us. When we got it, I sent the information via mail to my expert. I got a call from my expert last week, informing me that he had not yet received it, which was a little concerning to me. So we talked about what we were going to do. We ended up setting up a Dropbox and tried to do it that way. That worked, but I'm going to need a little time if the state will indulge me.
Any objection from the state?
No objection, Your Honor. Thank you.
All right, court will reset Mr. Ball's pretrial hearing Tuesday, December 3rd at 9 a.m. And once he signs his notice, he is free to go.
And Mr. Benjistu.
CR 24-143, State of Texas versus Obed Baru Mengistu. And you indicated that you believe that he was in custody in Dallas County.
Yes, sir. I had spoken with his mother. He was there. He had a judge. He had a lot of charges down there or over there. So I'm afraid he's going to be there a minute. I spoke with Mr. Hartwell about it. I mean, we had a deal in place pretty quickly on this. And then when he caught those new charges, that deal is going to be pulled off the table. And I understand that. And depending on what they do, the charges that he's, as far as I know, because I'm not representing him, but what he's been accused of in Dallas, penalty group wise, is far more serious. So this may be one of those cases that ends up taking care of itself.
Yes, Your Honor. We're kind of just waiting to see how Dallas County proceeds. That could very well determine how we handle the case here.
All right, court will reset Mr. Mengistu's pretrial hearing. We'll just do a status on December 3rd, since you'll already be here, Mr. White. We'll see if there's any changes in Dallas County.
And then we've got Mr. Homer for a plea, Your Honor.
Richard Homer, CR 24-74.
Your Honor, Mr. Homer, he doesn't hear as well as he'd like to now. And so, speak up a little.
I will do.
He's having some problems.
I will do. All right, Mr. Homer, can you hear me if I talk at this level? Can you hear me okay? Okay. All right, this is cause number CR 24-74, State of Texas versus Richard Kevin Homer. Mr. Homer, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. All right, Mr. Homer, are you a United States citizen who reads, writes, and speaks English?
Yes.
Here, Mr. White, why don't you come on up here? It might be easier. Mr. Homer, come on up. Does it help if you're closer?
Yes.
Okay, good. All right. So I asked if you were a United States citizen who reads, writes, and speaks English.
Yes.
Okay. And in this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes.
Are you pleased with the work that he's done for you?
Yes.
Is there anything that you do not understand about the paperwork that your plea agreement that you've read and signed today?
No, sir.
All right, and Mr. White, do you believe that Mr. Homer is competent to enter into a plea? And if so, have you advised him of his rights, including the advantages and disadvantages of a deferred adjudication plea?
Your Honor, I believe Mr. Homer's competent. He understands the proceedings of opinion against him here today. Your Honor, I've also explained to Mr. Homer his rights. I believe he's waived those rights knowingly, intelligently, and voluntarily. He also understands the advantages and disadvantages of a deferred adjudication. Most notably, if he violates any term or condition, the court will hold a hearing to determine whether or not he did in fact violate it. The court finds by preponderance that he did. He's looking at up to 10 years and $10,000 fine.
Thank you, Mr. White. All right, Mr. Homer, you were originally indicted by the grand jury with the first degree felony of aggravated assault against a public servant. I see today that the plea agreement is, the state is recommending to the court that you plead to a lesser offense of deadly conduct, discharge of a firearm, which is a third degree felony and carries a punishment range of not less than 2 years in prison up to that maximum 10 years in prison that Mr. White referenced. You understand that?
Yes, sir.
You could also receive a fine up to a maximum $10,000. Do you understand that? I see that the plea agreement in your case is upon your plea of guilty to that third degree offense of deadly conduct, discharge of a firearm, that the state is recommending that the court consider the evidence, but not convict you today, but place you on deferred community supervision for a period of 5 years, along with a $2,000 fine plus court costs. And the state would ask the court to dismiss an unfiled charge, also deadly conduct, discharge of a firearm. Is that your understanding of the plea agreement?
Yes, Your Honor.
And is there anything, do you understand everything that's happening in court today? And do you have any questions before we go any further?
No questions.
Excellent. Okay. All right, Mr. Homer, understanding the range of punishment, understanding the plea agreement, I would ask you, how do you plead to the lesser offense of deadly conduct, discharge of a firearm, a third degree felony?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept Mr. Homer's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection, Your Honor.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance and law enforcement is supportive of the plea.
Thank you, Mr. Hartwell. I do appreciate that. Anything further from the defense?
Your Honor, I just very quickly, I would note, I believe Mr. Holmes told me today that today he is 1 year sober. He's went through quite a bit of treatment, try to get right. I've known Mr. Holmes for a while. I know that this hasn't been the easiest thing for him, but he's made a tremendous effort to get back to where he needs to be. And I'm certain, and I know that Ms. Curry took that into account when coming to this decision to do what we've done. And I think we're all kind of proud of the effort he's put in.
All right, Mr. Homer, you want to say anything about that, about your sobriety?
1 year bound and through without help.
Was it hard?
Yes.
It was. Well, I'm looking for honesty. If you were to tell me that it wasn't hard, I would not believe you. So I expected you to say what you did. Is there anything else that you would like to say to anybody that's dealing with this same kind of issue?
Don't do it.
Don't do it. All right. Thank you, Mr. White. All right. Court's going to consider the evidence. All right, the court has considered the evidence, finds that there is enough evidence to convict Mr. Homer. The court will follow the plea agreement and the recommendation of the DA's office. Court hereby defers a finding of guilt on the lesser included offense of deadly conduct discharge of a firearm, a third-degree felony. The court places Mr. Homer on 5 years community supervision, orders him to pay a $2,000 fine, $290 court costs, and $35 in reimbursement fees. And the court does dismiss under section 1245 unfiled DA 2023-1173, deadly conduct discharge of a firearm. All right, Mr. Homer, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over here with Deputy Martinez. He's gonna take your fingerprint. After that, you'll meet with the probation officers.
Your Honor, I've got a case this afternoon, so I'll see you on the docket then. Just so that's all. With no boy.
Come on up. All right, Mr. Quaid, this is cause number CR 24-222, CR 24-223. You are set for arraignment, Mr. Quaid. You are charged with two crimes, one being a first-degree felony offense of manufacture or delivery of a controlled substance greater than 400 grams. That one carries a potential punishment not less than, if you were to be convicted and sentenced to prison, would be not less than 5 years in prison or more than 99 years or life confinement in prison, and a possible fine not to exceed $10,000. And you're also charged with possession of marijuana between 5 pounds to 50 pounds. That is a third-degree felony, carries a potential range of punishment not less than 2 years in prison, up to a maximum 10 years in prison, and a possible fine of not more than $10,000. Is it my understanding that you are attempting to hire an attorney to represent you on both crimes? Yes, sir. Okay. And I have a note here that says that you are trying to retain Mr. Brent Thorson. Is that correct? Yes, sir. When do you believe you'll have that completed?
December.
December? Yeah. So if I reset you to December 3rd or 5th, you can come back with Mr. Thorson?
Yes, sir.
Okay. All right. I'm going to take you at your word, Mr. Quaid. The court's going to reset Mr. Quaid to Thursday, December 5th for arraignment and status on attorney. All right, Mr. Quaid, I want you to make it a priority to get either Mr. Thorson or any other licensed Texas attorney in criminal law retained. Okay. And Mr. Quaid, since you have posted bail in each one of your cases, and you're now in this court, the court is issuing conditions of pretrial release. And these are conditions that you have to comply with to stay out on bail. You're gonna have to drug test it, you can't commit new offenses, you're gonna have to report. And so that's gonna require you to sign conditions of pretrial release and have a pretrial release officer, okay? So I want you to come over here and meet with officers and they will give you the paperwork, they'll go through it with you, you'll sign that and get a copy of it, okay?
All right.
All right. Ma'am, are you with Mr. Quaid? All right, when he gets done, he's gonna exit out a back way. So if you just wanna wait in the hallway, he'll be out shortly. Also didn't miss daily like that, right? Mr. Duncan also, sorry, I write it down on their paperwork, but I never write it down. Ray Williams. Come on up, Mr. Williams. This is cause number CR 24-226. Oh. It's no, I'm sorry. Mr. Williams, I apologize. I didn't realize that I had given you a court appointed attorney and he's outside and he's working with another client. So I'm sorry. Have a seat. I'll call you right back up in a minute. Hey, y'all gone over the paperwork.
Yes.
Caleb Waller. All right, Mr. Waller, you're here on your sanctions court. All right, let's see, at the last court hearing, I ordered you to pay $65 to probation. You did that. Ordered you to pay $45 to the district clerk. My note said that you did not do that.
I did do that.
Do you have your receipt?
I do.
All right, can we get a copy of his receipt? Did you pay that before today?
Yes, sir. $45. There it is.
Thank you, sir.
No problem, sir.
All right, I will correct my records to show that you did comply with that.
Yes, sir.
All right, and then what about your community service?
I did get it done, sir. I do have one favor to ask though. Instead of doing community service out of Henderson County, can I please do it out of Van Zant? As Henderson County is, I had to split the time you told me to do between Van Zant County and Henderson County because the things they had going on are not going on. I ended up having to do trash pickup in Henderson County, and I did the memorial museum. I did that.
So you're asking to do all your community service over here?
I like to do it out of first Monday,
Yeah.
Saturday and Sundays of every month.
Yeah, that's not a problem.
Okay.
That's not a problem. Just sign up to get that done, okay?
Yeah, no problem, sir.
All right, so this is what we'll do. I'm gonna have you come back on December 3rd.
Okay.
And let's see here. It says that you'll need to pay 130.
No, sir. It hasn't updated yet.
Go ahead and update it, yeah.
No, sir. And it will reflect that by the end of this week.
All right, $65 to probation,
Yes, sir.
and let's do. Let's do the same thing, $45 to district clerk, $65 to probation,
Yes, sir. It'll be taken
20
care of Thursday.
20 hours community service. And so if you want to work first Monday, you'll need to,
It will all be done this week.
okay, let's say that, that'll have to be done this coming month.
Yes, sir.
Okay, all right, we'll bring you back on December 3rd, all right?
Awesome. Thank you, sir.
Mr. Cheatham? All right, Mr. Cheatham. All right, last sanctions court, let's see, I ordered you to pay 120 to probation, 100 to court collections. And work 15 hours community service. It says that you did do your 15 hours community service. Where'd you do that at?
Love and grace.
Okay, same place. And it said that you paid your court collections, but you paid on the day of sanctions court, correct?
Yes.
All right, so I really need that paid the week before so that my records can be
Up to date.
okay? But it says that you did not pay your probation fees, did you?
Yes, I paid it. I paid $280. So, my direct deposit was messed up that day. So when I ended up losing my card and all of that happened, it just messed everything up. So I switched it all over to my Navy Federal account.
Okay. You still working at the air, or you're truck driving now, right?
Yes, sir.
Okay. Remind me, is it short haul or long haul?
Long haul and short haul. It's in them.
All right, so I'm gonna bring you back on, are you gonna be here on December 3rd?
Yes, sir.
You are? Okay. Let's do. Let's do 15 hours community service. 100 to court collections. And 150 to probation. Okay, I gotta start getting you caught up. And I need those the week before you come to court so that I don't have to scratch out all this stuff, okay? All right, once you sign, you're free to go. like that. Hey, capital data. Isaiah Rosser. All right, Mr. Rosser, let's see, you were here on September 24th. And we talked about three things: paying $75 to probation. I'm sorry, $70 to probation, 150 to court collections, and 25 hours community service. My records say that you paid the 150 to court collections. It says you did not pay the $70 to probation.
Yes, sir. I was going there after, I didn't have enough time to get the money ordered to take to probation, this morning.
You have that today?
Yes, sir. I have it today. I'm going there after this.
What about your community service?
I sent the man to my probation officer in Dallas and, here in Vincent to Ms. Danielle.
What did you do? You're saying that you worked 25 hours?
Yes, sir.
And what did you do for those 25 hours?
I had passed out food. We passed out food. It's like a gym. Miss Marcellus, I just help him around his warehouse and stuff like that.
So you're saying that you did all that before Friday of last week?
Yes.
When did you do it?
So when?
When did you do it? Like what dates did you do it?
I have to look.
Do you have any, like, are you taking pictures of your
Yes,
sign-in sheets and all that? You have all that?
Yes, sir.
I can see that. So, Mr. Rosser, how much time did you do?
I believe I did like 50 each month.
Yeah, because it's showing about 48 for October.
For October. Yes, sir.
All right, I'm just gonna wait for the two offices to verify each other, okay?
Yes, sir.
All right, so what we'll do is I have you come back on December 3rd, $70 to probation,
Yes, sir.
150 to court collections, and minimum 25 hours. If you do 48 or 50, that's great. Okay. There may be a delay in getting it from Dallas County to Van Zandt. I understand that. So, all right. I would continue doing what you're doing. I would always take pictures.
Yes, sir. Because remember he went to police last month and he's been keeping track of them, and he'll send me the email, the PDF.
Good to see you. Free to go. Mr. McSpadden? All right, Mr. McSpadden, let's see. I had ordered you to pay 120 to probation, 80 to court collections, to do 20 hours community service. We talked about your medical documents from your surgery. And let's see, it says here that you paid your $80 for the court collections. But it says that you did not pay your 120 to probation. Is that right?
I paid on two different websites. I don't know. You ordered me to pay the 180. Usually before I paid 60 and 40. I have to pay for transportations. I'm limited to my financial, but yes, sir, I did.
You paid your 120 to probation over there?
Online, yes, sir. No, I just paid the first one you said, the 80.
Right, I'm asking,
No, I haven't. I didn't. I guess I messed up. I didn't pay it.
Why did you not pay your probation fee?
I paid a little bit on both websites, so I don't understand. I didn't pay the full amount, Your Honor. I paid some. I didn't pay until yesterday. I had to report to Quitman yesterday to the probation officer over there. So, and that's when I paid online.
What about your community service?
I turned that in yesterday, 72 hours.
And where did you do that?
I'm a Helping Hands in Hawkins.
Where were we at on your medical documents that you were gonna?
I went to the VA like I told you, and my physician, she also submitted because it comes out of the main Dallas facility. So we're at this point, I'm just waiting to receive the record. And on that, Your Honor, when I was on pretrial, I believe I had already submitted that. I don't know if there's any way to find that on the records or anything.
Yeah, they say they don't have that.
Okay,
All right, so I'm gonna have you come back on December 3rd.
yes, sir.
I need 120 to probation.
Okay,
Okay, all of that to probation.
all right, yes, sir.
I need 80 to court collections, 20 hours community service.
Yes, sir.
And we need to have the hernia documents,
Yes, sir.
23. If you're still waiting on VA, I know that won't be your fault, right? But I
Right.
want to continue to ask you about it until we get it done.
Yes, sir, I understand.
All right, we'll see you back on December 3rd. She's gonna bring you a notice to sign.
Thank you, Judge.
Mr. Schmidt, you ready? Who would you like to call first?
Ray Williams.
Mr. Williams. Right, this is cause number CR 24-226, State of Texas versus Ray Anthony Williams. For arraignment, the court has found Mr. Williams to be indigent for purposes of counsel and has appointed the Honorable Richard Schmidt. Go ahead, Mr. Schmidt.
Judge, we received a copy of the indictment. We've gone over that. His name's correct. We waive formal reading and a plea of not guilty.
All right, court enters Mr. Williams' plea of not guilty into the record. Court sets this matter for pretrial hearing on Tuesday, December 3rd. Donnie.
Pre-leave, I'm not sure if he signed
Uh,
the pretrial.
I believe he has signed this. Oh, he has on. Oh, I thought you said he had. That's why I checked it on. Mr. Williams, so because you're indicted here and you posted bond, court's gonna put conditions of pretrial release that you have to comply with, which means that if you violate those, the court could have a hearing, could revoke your bail, put you back in jail, okay? They're gonna have all that paperwork for you, okay? Mr. Schmidt.
Austin Hensley.
Mr. Hensley. This is clause number one. Austin Keith Hensley, CR 22-274, motion to adjudicate. Go ahead, Mr. Schmidt.
Judge, I was appointed to represent Mr. Hensley on the motion to adjudicate, this morning, received a copy of that. Not ready to proceed. We'd ask for a 30-day reset.
All right, court will set Mr. Hensley on the evidentiary docket on Tuesday, November 26th.
Evan Page.
Mr. Page. This is cause number CR 19-63, State versus Evan, Andrew Page. Docket call. Go ahead, Mr. Schmidt.
Judge, we're here on doc call. I think we're close to resolving the matter. I'm still waiting on some documents from, the federal authorities, to provide to the DA's office. We'd ask for a final docket call on Mr. Page.
And no objection, Your Honor.
Thank you, Mr. Arwell. Do you have any idea about how long it may be?
I hope not long, Judge. If we could set us for that 12-3 docket,
Okay.
hopefully we'll have it resolved.
All right, court sets Mr. Page for docket call December 3rd at 9 a.m. Free to go.
Gerald Holmes.
Mr. Holmes. This is cause numbers CR 24-55, 56, and 57, all for docket call. Go ahead, Mr. Schmidt.
Judge, I met with the state last week. We received I believe a final offer on Mr. Holmes's case. I'd ask for a final docket call and give me an opportunity to explain that to Mr. Holmes and either resolve it or set up a trial.
State.
No objection, Your Honor. Thank you.
All right, court will set Mr. Holmes for a final docket call December 3rd, 9 a.m. in each case.
Yeah.
Here you go.
Robert Wales.
Mr. Williams. You say Wells or Williams?
Wales, W-A-L-E-S.
Wells, yes, I'm sorry, I think you said Williams. Robert Michael Wells, CR 17-266. Clients, go ahead.
Judge, I think we're gonna have to try to work this out, but we've been carrying Mr. Wales for compliance. I'd ask that, he be set on the November evidentiary docket. A potential contested hearing if necessary. If not, we'll resolve it that day.
Any objection from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Wells on the evidentiary docket Tuesday, November 26th. Good go.
Did Mr. Elwood appear this morning, Judge?
Oh, yes, Joshua Theron Elwood. I heard his name called. I checked him off as here. Ms. Abraham indicated to me that Mr. Hoag answered affirmative for Mr. Elwood, so Mr. Elwood is not here.
In that case, I'm prepared to proceed with Elizabeth. Wow.
Ms. Black. CR 24-91. There's a lot of spindles in your car. I think there's on this one. All right, this is cause number CR 24-91, State of Texas versus Elizabeth Diane Black. Ms. Black, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Elizabeth Diane Black.
Yes, sir.
And Ms. Black, are you a United States citizen who reads, writes, and speaks English?
Sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir.
Do you understand everything you've read and signed as part of your plea agreement?
Yes, sir.
Do you have any questions before we go further?
Sir.
Mr. Schmidt, do you believe Ms. Black to be competent? And if so, have you explained to her her rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Ms. Black, you were originally charged with the third-degree felony offense of assault of a family or household member by impeding breath or circulation. I see today that there's a recommendation from the state in your plea agreement that you, upon your plea of guilty to a lesser offense of assault causes bodily injury of a family member, a Class A misdemeanor, which carries a range of punishment of up to a maximum 365 days in the county jail and a possible fine not to exceed $4,000. I see the plea agreement is on your plea of guilt that the court to consider the evidence, but defer a finding of guilt. That means not to convict you and to place you on 2 years of community supervision with a $650 fine plus court costs of $270 and reimbursement fees of $535. Ms. Black, is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Guilty.
And Ms. Black, are you pleading guilty to that lesser charge and crime because you are in fact guilty of committing that crime?
Sir.
And Ms. Black, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, then the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence? Stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, just that the state is in compliance, victim impact statement was set up or sent out, was not returned.
Thank you, Mr. Harwell. Anything further from the defense?
No, sir.
All right, court will review the evidence. All right. Then the court, having reviewed the stipulation of evidence and the indictment in this charge, finds that there is enough information and evidence to convict Ms. Black of this offense. However, the court will follow the plea agreement and the recommendation of the DA's office. court hereby defers a finding of guilt on a lesser included offense of Class A misdemeanor assault causes bodily injury of a family member. The court places Ms. Black on 2 years community supervision, orders her to pay a $650 fine, $270 court cost, and $535 in reimbursement fees. Ms. Black, you're emotional today. Why are you emotional?
Because it should have happened.
Is it remorse, regret that you're experiencing? It is. Well, that's a good thing in my eyes. That's what you're experiencing. That's a good thing because that's what's to be expected and normal. Ms. Black, you hereby remanded to the custody of the probation department until they carry out the terms and conditions of the sentence. I can have you come forward to be fingerprinted with Deputy Martinez. After that, then the probation officers will give you more information. Charles Paul Huff, cause number CR 24-181. All right, Mr. Huff, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you. You can lower your hand. Your name is Charles Paul Huff?
Yes, sir.
And Mr. Huff, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Bipolar.
Okay, are you currently on medication or under treatment for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in court here today?
I'm good. I mean,
Can you recall a time when you're not good?
I've been real good for about 8 years now.
Okay. So I guess what I'm asking is, can you tell when you're not good versus when you're good mentally?
So, I guess, when I start cycling, I'll stay in the house, you know, stuff. I know when it's coming.
Okay.
Truly understand what you're getting yourself into, you know, any mental illness that
Oh,
you may
yes, sir.
have.
Yes, sir.
See what I'm saying?
Yes,
Okay,
sir.
good. And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work he's done for you?
Oh, sure. Yes, sir.
Do you understand everything that you've read and signed that's in the plea papers?
Yes, sir.
All right, do you have any questions before we go further?
No, sir, no.
Mr. Schmidt, do you believe Mr. Huff to be competent?
Yes, sir, I do.
And you haven't seen any signs of any kind of mental health disorder that would cause you to doubt that?
No, sir.
And Mr. Schmidt, have you explained to Mr. Huff his rights as they pertain to this case? And also the advantages and disadvantages of a deferred adjudication plea?
I have on both counts, Judge.
Thank you, sir. All right, Mr. Huff, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. However, I see that part of your plea agreement today is the state's recommending that you be allowed to plead guilty to a lesser offense, possession of a controlled substance less than 1 gram. In that case, the range of punishment would be for a state jail felony, and that would have a range of punishment of not less than 6 months in a state jail prison or more than 2 years in a state jail prison if you were to be convicted. I see the recommendation is that upon your plea of guilty, The state is asking the court to consider the evidence, not convict you, and place you on community supervision or probation for a period of 3 years. And as part of that, besides all of your other conditions, you're also going to have to pay a fine of $1,750, court costs of $290, reimbursement fees of $535, and restitution for the testing of the substance in this case of $180. Is that your understanding?
Yes, sir.
Is that what you're asking the court to approve?
Yes, sir.
All right, then, Mr. Huff, I've explained the range of punishment. I've also explained the plea agreement. So at this time, I would ask you, how do you plead to the lesser offense of possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that
I
crime?
was guilty from word get-go.
Understand. Then the court will accept the defendant's plea of guilt at this time. Mr. Huff, has anybody threatened, forced, or pressured you to plead guilty?
No, sir, Your Honor.
All right. Court takes judicial notice of Mr. Huff's judicial confession. Mr. Schmidt, any objection to the stipulation of evidence?
No, sir.
All right, stipulation of evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
No, sir.
All right, the court's going to review the evidence. All right, the court finds that there is sufficient evidence to convict Mr. Huff of this offense. The court will follow the plea agreement and recommendation of the DA's office. The court hereby defers a finding of guilt on the lesser offense of possession of controlled substance in penalty group 1, less than 1 gram. The court places Mr. Huff on 3 years community supervision, orders him to pay a fine of $1,750, restitution of $180, court costs of $290, and reimbursement fees of $535. Mr. Huff, I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, you'll meet with the probation officers and they'll tell you about what's next. Other than Mr. Creel, is that all of your clients, Mr. Schmidt? Yes. Caleb Waller, I put him, he was sanctions court. I also put him on 12-3, right? You know what we need to do? Hang on, I'm sorry. We also need to call Mr. Bowie. Season. And the Dallas County. Oh, no, we did that. Mingus did, we did that one. So we'll need to call Bowie. Is he confirmed in Smith? Here, you can just write on there. We're gonna do 12-3. Arraignment and status in custody. Joshua Elwood. Joshua Elwood. Yes. Yes, absolutely. The court has called cause number CR 24-207, State versus Joshua Theron Elwood. Mr. Elwood was not present when his name was called, is not present at this time. Court hereby enters a judgment nisi and alias capitis. Court finds he has a personal bond, so the personal bond will be revoked at this time. All right, court's going to stand in recess until 11:30 for the final hearing on the court's criminal docket. Court's in recess.
Well, I'll step out and make a quick phone call.
She's not there. I see Miss Abney. She's the only one I see from your office.
Hi, Judge. David Corman, our doctor, he's letting the patients out there know that he's going to be doing this court hearing and he'll be with them afterwards. So he'll be back in like 2 minutes. He just went to go let him know.
Yes, ma'am. Thank you for letting me know. I appreciate it.
Of course. Thank you.
All right, we'll go ahead and go on the record. This is cause numbers CR 23-158, CR 24-206, State of Texas versus Brandon Ashley Frill. And the court has received an application for order to administer psychoactive medication filed by Dr. David Corman, MD. Dr. Corman will be appearing via Zoom today here in just a moment. Anything that the defense or state wants to put on the record at this time?
Judge, the only thing I would put on the record was, Mr. Krill's counsel is that he's been previously competent to stand trial. Normally, if my client currently competent, we would either agree or not. Generally, we would agree because we understand the importance of maintaining mental health, but for the circumstance, because he's been found incompetent, we're not on the record agreeing to the court administration psychoactive.
Thank you. Good morning, Dr. Corman. How are you, sir?
I'm good. How are you today?
I'm doing fine. I appreciate you being able and being available for us for Mr. Creel. I understand you got a very busy schedule. We'll do our best not to take much from that. And so I've already called the cases, and Mr. Creel is here today in court. You may be able to see him. He's with his counsel, Mr. Schmidt. And this is a hearing on your application for order to administer psychoactive medication. I'm going to go ahead and swear you in at this time, Dr. Corman. If you'll raise your right hand, Dr. Corman, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you. And can you go ahead and identify yourself for the record and state if you are a licensed medical doctor in the state of Texas?
Dr. David Corman. I am a licensed physician in the state of Texas.
All right, thank you, Dr. Corman. State, are you ready?
If I could have just 1 minute, Your Honor?
Yes.
Thank you.
Right here. That'd be great.
Mr. Hernandez?
Yes, Your Honor. Thank you so much. I appreciate it.
All right. Hey, Dr. Corman, can you see and hear Mr. Alfredo Hernandez?
I heard his voice a moment ago.
Okay. All right. Go ahead, Mr. Hernandez.
Thank you, Your Honor. Good morning, Dr. Corman.
Good morning, sir.
Are you board certified? Let me just ask you that question to start off.
Well, I was board certified and I would have had to renew it a few years ago, and I didn't renew it, but formally board certified in psychiatry.
Okay. And in this particular case involving the application for an order to administer psychoactive medication. How is it that you came about to be involved in this matter?
I was asked to interview and assess Mr. Creel. I work here at the Public Mental Health for Van Zandt County called the Andrews Center. And so I interviewed him and made an assessment.
And for purposes of that assessment, may I just have a brief rundown of your educational qualifications?
And Judge,
I'm a
Hang on,
licensed.
hang on. I'm sorry, Dr. Corman. I'm sorry to interrupt. Mr. Schmidt was going to say something.
I'd stipulate on behalf of Mr. Krill to the doctor's qualifications to proceed and to his expert standing.
Does the state accept that stipulation?
Yes, Your Honor, we would. Thank you.
All right, then the court finds that there is a stipulation that Dr. David Corman is qualified under the laws for purposes of this hearing today. The court does find that Dr. Corman has testified in this court previously. The court has found him previously to be an expert, and the court finds him today to be an expert for this matter. Go ahead, Mr. Hernandez.
Thank you, Your Honor. So Dr. Corman, is it true that you actually submitted an application for order to administer the psychoactive medication to Mr. Creel in this case?
Yes.
And how is it that you came about to reach that conclusion?
I interviewed him and I spoke with the jail nurse to get some history of events with Mr. Creel at the jail. And that's the data I used to reach that conclusion.
Okay, and based on that application, you filed that information with the court. Did you have to diagnose him first and foremost?
Yes, I did.
And was that, to your knowledge, filed back on October 21st of 2024?
I believe that's the correct date.
Do you have a copy of that document there that you can take a look at, sir?
Unfortunately, I don't have a copy of the document in front of me. But I saw him on October 15th, and we didn't have the precise documents we needed. So I believe the 21st was the date that I completed it and sent it. Hello?
Yes, I'm here. Thank you, Doctor.
Okay. I thought I lost audio. Sorry.
Yeah, no. Your Honor, I have a 4-page document purporting to be that application. I don't know if the court has access or the ability to share the screen so that Dr. Corman can see it.
I was just informed by Ms. Taberham that the clerks have not uploaded this into their system, so I do not have the ability to do it. Please. So Dr. Corman, give us just a moment. We're going to ask the clerks to upload your application into their system so that I will have the ability to display that on the screen so that you can reference it during your testimony. So it may take just a moment.
Okay. Yes, sir. Thank you.
just 1 second. I should be able to display this for you.
Oh, okay.
Dr. Corman, can you see that document on the screen?
Yes, I
Does it
can.
need- Does it need to be zoomed in or out?
I can see it. I can read it.
Okay. I'm going to go ahead and just give you a moment to review it, and then I'll allow Mr. Hernandez to continue questioning here. But let me go ahead and just give you a chance to kind of review it, refresh your recollection.
Okay.
And then I'll leave it up during the course of your testimony so that you can just tell me if you need to see a certain page. But
Okay.
if it needs to be larger, you just let me know.
It's good. It's kind of scrolling, and I'm reading it as it's scrolling, so that's working. All right. Very good. Thank you.
All right. And then Mr. Hernandez, if you'll just tell me what page you're referencing, and I'll make sure that I can get that displayed for the doctor. Go ahead.
Thank you, Your Honor. So so this is a copy of the application that you submitted. Is that right, Dr. Corman?
Yes, sir.
Okay. And let me ask you, just generally speaking, how many times have you filed this type of application with a court to administer psychoactive medication?
In my career,
Yes, sir.
Lord knows, 50 times, 100 times. I worked for the state hospital for 14 years in the past, so I've done this before.
All right, sir. And in this particular instance, you said you did have an opportunity to meet or interview Mr. Creed?
By televideo, just as we're speaking now. Yes.
All right, sir. And also you had access to the nurse there at the jail, you stated?
Yes.
Okay. And based on all that review, you were able to diagnose him. And what was that diagnosis for?
Schizophrenia.
Okay. And what did you mean? Pointing you back to this application for order, you also stated RO, bipolar disorder.
Well, that means rule out bipolar disorder, which means the same kind of psychotic symptom picture could appear in bipolar disorder. And based on one interview, and even with review, I did also have the opportunity to review some past records from his encounters with the Andrews Center, and the documentation by the psychologist who found him not competent to stand trial. So I had those sources of information. But based on all that, the possibility that the psychotic symptoms were due to bipolar disorder rather than schizophrenia still exists. So that's what rule out bipolar disorder means.
Thank you, doctor. So in terms of going through, you also state that you believe the patient lacks capacity. Can you just talk a little bit about that?
I felt that based on the interview, based on his symptoms, and based on his reported behavior, that his judgment about whether he needs medication treatment is grossly impaired.
And so for that reason, he would not be competent enough even to make that decision. Is that correct?
Yes.
And ultimately, what is it that you would hope to accomplish were the court to order that this medication be forced upon Mr. Creed?
To treat his psychotic symptomatology, by which I mean his hearing voices, responding to voices that no one else can hear, perhaps some of his behavior might be motivated by that psychotic experience, and maybe his behavior could be stabilized so that he would no longer be throwing trays at jail staff or smearing feces on himself or the walls.
And that favorable diagnosis, would that also lend itself to him being competent and able to stand trial?
It's the best chance of accomplishing that would be to treat the psychosis and thereby allow him to regain competency to stand trial.
And just finally, Dr. Corman, the copies of the report that you've seen on your screen there, does that fairly and accurately reflect the report that you filed or the order that you filed with the court?
It's the document I filled out.
Your Honor, at this time, I'd move for admission State's Exhibit 1 for purposes of this hearing, and I'd pass the witness.
There being no objection, the application for order to administer psychoactive medication is admitted as State's Exhibit 1 for purposes of this hearing. Go ahead, Mr. Schmidt.
Thank you, Judge. Good afternoon, Doctor. This is Richard Schmidt. I represent Brendan Creel. I'm looking at your application here, and you made a diagnosis of schizophrenia. Based on your review of Mr. Creel's records, has he been previously diagnosed with schizophrenia that you're aware of?
In the previous encounter with the Andrews Center, he was diagnosed with unspecified schizophrenia spectrum and other psychotic disorder.
And can you explain whether there's a difference between a diagnosis of schizophrenia and the one you referenced, schizophrenia unspecified?
Yes, I think they were trying to account for the fact that that he had evidently been abusing methamphetamines, and to include the possibility that heavy amphetamine abuse might account for the symptom picture rather than chronic schizophrenia.
At this point in time, Doctor, are you comfortable medically and psychiatrically with a solid diagnosis of schizophrenia?
I'm comfortable with that because I'm resting on the assumption that during the months that Mr. Creel has been incarcerated in Van Zandt County Jail, he's not had access to methamphetamine, but his symptoms have nevertheless persisted for those many months. So that I think we can eliminate the thought that it was strictly and only due to drug use.
Based on your review of Mr. Creel's records and your investigation, as well as your interview of Mr. Creel, have you been given any indication of any sort of malingering on behalf of Mr. Creel?
I felt I did not see evidence of malingering, and I felt rather, in fact, that he was trying to minimize his symptoms rather than exaggerate them.
And Doctor, on your application on paragraph 4, on the first page, you have checked both boxes that the requested administration of medications is customary and that it is not customary. Could you explain that real quick?
Well, I may have misunderstood it when I did it, but I believe I was thinking that I'm accounting for by mouth or intramuscularly, as I say above, and the customary method is orally by mouth. But the less customary method of, if he refuses, of giving it by intramuscular injection would also be a consideration. So that's why I guess I checked both boxes.
Thank you, Judge.
To account for both possibilities.
Yes, sir. That's what I assumed you meant. On the administration process, is there a less invasive method in which to deliver these medications under the circumstances?
Well, no, there's only orally or by injection are the only two options, and he would be offered medicine to be take by mouth and hopefully do that. But if not, there would be the alternative of intramuscular.
So absent consent, this is the only other method in which to administer the medications. Is that correct?
Yes.
Now, Doctor, you had also submitted a Exhibit X with your application. in which you have circled several medications. If I could briefly ask you about those medications, I believe one of them is trazodone listed under the antidepressants. Can you state to the court what the use of trazodone is in Mr. Creel's particular case?
Well, if we needed to, that would be to use it. That would be an antidepressant that we just use to help with insomnia. I don't anticipate that we would start with using it, but we might want that option in case he's still having trouble sleeping, even if he's on the primary medicine, which would be the antipsychotic.
Is that an oral or a intramuscular injection?
That would strictly be oral.
Then you circled risperidone or Risperdal under antipsychotics. Is that the primary medication that Mr. Creel you believe needs?
Yes.
And what is the purpose of that medication?
That's to reduce or eliminate hallucinations and other associated psychotic symptoms.
Would that be administered intramuscularly?
If need be, it can be administered intramuscularly.
You circled the valproax or sodium or Depakote. What is the purpose of that particular medication?
That's a mood stabilizer, and sometimes we need to add that for a patient who's remains agitated or excitable or unstable in mood despite the antipsychotic. But again, I don't necessarily anticipate we'd need that, but we might.
And Doctor, I do know that Mr. Creel has complained of insomnia and inability to sleep. Do any of these medications affect his ability to sleep, or do they aid that?
All of them would. All of them might aid that, and rather than interfering.
To your knowledge, there are none of these medications that would prevent his ability to sleep. There is no stimulant effects to any of these medications that would keep him awake that you're aware of. Is that correct?
No, all of them are likely to promote sleep.
And is it your medical opinion that if this order is not granted, that Mr. Creel will continue to deteriorate?
Yes.
And if it is granted, is it your opinion that he's likely to improve to the point that not only would it affect his mental health in a positive way, but that also he's likely to regain competency?
Yes, he's likely to. There's a greater chance that he would regain competency as a response to the medicine.
Thank you. Pass the witness.
Mr. Hernandez.
No follow-up questions, Your Honor. The state rests.
All right, anything further, Mr. Schmidt?
No, sir. We'd rest as well.
Dr. Corman, is there anything else that you would like to give testimony on that was not asked by either counsel that you think would be important for the court to know regarding Mr. Creel?
No, sir.
Okay. All right. Any objection to Dr. Corman being excused?
Not from the state, Your Honor. Thank you.
Dr. Corman, I appreciate your presence here today. Appreciate your testimony. Appreciate your patience while we got things situated. Have a good day, sir.
Thank you, sir. You too.
So we need to take it voluntarily.
All right. State has rested. I believe the defense has rested too, Mr. Schmidt. Is that right?
Voluntarily. Now, until we get to the point where you're so confident that we're gonna take care of this business, and we will take care of this business. But the quicker, the better, because the longer we're fucking with this, the longer you're sitting on this stuff, right? So let's get this behind us. Cool. Okay.
I believe the defense has rested too. Is that correct?
Oh, sorry, Judge. Yes, we've rested.
Any argument from the state?
No, Your Honor. Rest on the record. Thank you.
Any argument from the defense?
No, sir.
All right. Then the court does take judicial notice of the filings in cause number CR 23-158, CR 24-206. Court finds that there is clear and convincing evidence that Mr. Creel is subject to a court order for inpatient mental health services under Chapter 46B of the Code of Criminal Procedure. The court, having considered the evidence contained in State's Exhibit 1, in addition to the testimony of Dr. David Corman, or also having considered any evidence regarding the patient's expressed preferences regarding treatment with psychoactive medication, any evidence, which there is none, regarding patients' religious beliefs, the risk and benefits from the perspective of the patient of taking the psychoactive medication. The court finds there is none. The consequences to the patient if the psychoactive medication is not administered. Court finds that Dr. David Corman has opined that he believes that that Mr. Creel, the patient, would experience further deterioration. The prognosis for the patient if the treatment with psychoactive medication is not given. The court finds that the prognosis for restoration under the incompetency order is likely to be attained quicker with the administration of medication. Court finds that there are only two ways to administer the medication, either orally or intramuscularly, as opined and testified by Dr. Corman. Court finds that there are no less intrusive treatments or available options for Mr. Creel that are likely to secure the patient's agreement to take the psychoactive medication with consent. So the court does find that there is clear and convincing evidence that the defendant does lack the capacity to make a decision regarding the administration of the proposed medication, and treatment with the proposed medication is in the best interest of the patient, and that the patient has been ordered to receive inpatient mental health services by this court, which is a court with criminal jurisdiction over the payment, the patient, and that treatment with the proposed medication is in the best interest of the patient, and that the patient has been confined and remains in a correctional facility as required and defined by the law. And so therefore the court finds that it is ordered that the Southern Health Partners Andrew Center, by and through its agents, it is authorized to administer to the defendant, Mr. Brandon Creel, regardless of his refusal, the class or classes of psychoactive medications as specified in the application completed by Dr. David Corman, which is the antidepressants, antipsychotics, and mood stabilizers. It is ordered that Southern Health Partners or Andrew Center, by and through its agents, are ordered to administer any appropriate tests, including blood tests, to determine the types of medication and dosages of medication appropriate for the patient. Court also finds that during the period that the order is valid, that the dosage of the authorized class or classes of medication can be increased or decreased, and the restitution of the medication authorized but discontinued, and the substitution of the medication within the same class or classes is permitted. And the court orders that this order will be in effect until the earlier of the following, either the 180th date after the date the defendant was returned to the correctional facility by the inpatient mental health facility, or the date that the defendant is acquitted, convicted, or enters a plea of guilty, or the date on which the charges in the case are dismissed. Court hereby is signing the order authorizing the administration of psychoactive medication regardless of patient refusal. Right, the court is going to tender this order to Ms. Taberham. She's going to file this. Court is attaching to the order the application filed by Dr. Foreman. And we will provide copies to both the state and to Mr. Creel through counsel, Mr. Any further questions from the state?
No, Your Honor, thank you.
Anything further from the defense? All right, court has signed that order. Ms. Abraham, if you'll go file mark that, provide a copy to both the state and the defense. All right, that will conclude this hearing, and the court's going to stand in recess until 1:30.